Thank you again for coming out.
Thank you for having me. I just hope Professor Beale doesn't make me look too bad.
No, no way. No way.
She's signed for life.
They can always videotape her hallways anywhere. Real surveillance program.
But I hope the teachers union negotiated heavily for,
The DVD distribution.
Yeah, the DVDs, that's good. I think there's really a lot of pizza here. People should take a lot, but they shouldn't go to sleep in their afternoon classes, right? They have to kind of balance those two things against one another.
Trade-off.
Yeah, I guess we could just start at 5 in the morning or something. You know, get all done by 1.
We're still up doing homework at that time anyway, so.
Yeah, that'd get 8 hours.
I don't know what's the name of our event.
And I
Sort of.
still have our in for the year, so.
Five would be like so, but hey,
Now, we have till 15 after, what's the time?
Until, we could push it, I know you have to leave at 1:15.
Yeah, I have to leave quarter after.
I could
Professor
stay
Beale's
for a
class is-
couple minutes
Yeah.
more if this classroom's available.
It
It
is,
is
because
today.
we would normally be in it, but we moved over to the courtroom for the arguments, so.
Okay, so yeah, we can push it closer to 12:30, but a lot of people might have to leave if they have class.
Oh,
I think
we'll
the
get
audience
started.
at the next class is gonna be-
yeah, that's right. Okay, well, we'll try to cut it around, and if one or two want to stay, they can come up to the.
Perfect. We'll get started then in just a couple hours.
So that we. But I think we should.
Yeah, why don't you,
And
Sarah, why
Adam,
don't
I
you
think
go?
we should get started.
Good afternoon. Thank you, everyone, for coming. This is an event co-sponsored by the Federalist Society and the Program in Public Law. Our speakers today are Todd Gaziano. Mr. Gaziano is the director of the Center for Legal and Judicial Studies at the Heritage Foundation, and we're delighted to have him here. He's doing a bit of a tour of the Research Triangle area. We'll be speaking at UNC later this evening if you can't get enough at lunchtime. That's at 5:15, I believe.
We don't know whether there's any food then.
I'm not sure. Mr. Gaziano focuses on legal and judicial reform and constitutional issues, such as ensuring that all citizens are accorded equal treatment under the law. Mr. Gaziano has served under noted conservative leaders in all 3 branches of the federal government. He was chief counsel to the House Subcommittee on National Economic Growth, Natural Resources, and Regulatory Affairs, where he worked on government-wide regulatory reform legislation for Chairman David McIntosh. He served in the Office of Legal Counsel in the U.S. Justice Department, which provides advice on constitutional and legal issues to the President. He also served as a judicial law clerk to the Honorable Edith H. Jones, United States Judge on the Fifth Circuit Court of Appeals. Mr. Gaziano received his JD at the University of Chicago Law School, where he was selected as a John M. Olin Fellow in Law and Economics. We're delighted to have him here. He will speak for about 25 minutes, and then Professor Sara S. Beale, who many of you know as the Charles L.B. Lowndes Professor of Law here at Duke Law School, will speak for about 10 minutes, and then we'll open it up to questions from the audience. So thanks again for coming, and help yourself to more pizza. I think there's plenty. Thank you.
Thank you very much for coming, and I'd especially like to thank Sarah and Adam and all the other students who've done a lot to bring me down here. It's not too hard to get me down here, but the scheduling to coordinate the different events was more difficult than normal. But I am delighted also to be here with Sara S. Beale, who we've tried to draw attention to and in some of our own work at Heritage, and this is hope to demonstrate the fitness of the title, the criminalization of almost everything, why liberals and conservatives should be worried, or why everyone should be worried. And I'm trying to only take 20 minutes so that we can have a little bit more discussion afterward. But the three areas I'm going to try to cover briefly are, I'm going to give you a maybe baby refresher course in criminal law theory. Then I'm going to try through some anecdotes to explain why it was that I reviewed those principles. And finally, talk a little bit about the statistics that reflect what I think is the problem and some of the reform goals or reform objects anyway. In our sort of refresher on criminal law theory, I'm trying to keep my watch prominently. I'll put it here. I just want to remind you all of some of the basic distinctions you all learned in your introductory criminal law course. There were the procedural protections against abusive prosecutions or wrongful prosecutions that sort of reflect Blackstone's notion that it was better that 10 guilty people go free than one innocent person be prosecuted. And these are very familiar to not only lawyers, but anyone who watches crime TV. The presumption of innocence until proven guilty, the heightened requirement of proof criminal guilt beyond reasonable doubt, extensive due process of law requirements, right to counsel, right to grand jury, and trial by your peers, no charges, know the charges of which you are accused, many other privileges, attorney-client privileges, which, by the way, let me pause on that one. The attorney-client privilege undeniably gets in the way of the search for the truth, but serves another, I believe, and we all believe, apparently higher end of justice. Anyway, you all are familiar with the procedural protections, and in your upper level courses, that's where criminal procedure, except those may be taught by Professor Sara S and Beale, that's where you spend the majority of your time. But beyond the procedural ones, I'm going to go back to your really first week of law school, or first week of criminal law class, and those are the substantive notions that developed in the criminal law. And I submit it is these substantive notions, substantive protections, which are the ones most at risk right now. Sometimes they're taught in other people's courses as mere sort of historical antecedents, historical developments, and then kind of ignored after the first month of law school. But let me remind you of what some of those are. Both of these substantive components are based on the moral notion that the criminal sanction should not be imposed on, should only be imposed, I should say, on someone, let me actually look at my notes, who, one, committed an act that was inherently wrongful, and two, did so intentionally. The flip side of this is that it is malicious to impose criminal punishments for purely accidental wrongs or for otherwise innocent behavior. Now, this old distinction between what was civil and criminal often turned on this fundamental moral notion. And I believe this is a moral notion that should not be trivialized by politicians seeking to curry favor with the public and criminalize the problem du jour. Let me sort of go over those two requirements just a little bit more. Beginning with Cicero, in Roman times, he talked about those things which every civilized society criminalized. He sort of distinguished natural law or natural wrongs from sort of local laws, which side of the street you can park your chariot or whatever. And this became part of what we considered the traditional crimes were those which every civilized society, murder, rape, robbery, punished. And but we do still forgive people who, perhaps because of insanity, don't know the nature of right and wrong. The other element, of course, of the traditional criminal protection was the intent requirement, a serious mens rea requirement. There are a few fancy exceptions to this that you learn in law school, but essentially you've got to intend the consequence of your actions, such that we do not criminalize accidental killings, we do not criminalize as theft the bank teller who gives an amount of money which is wrong, but not knowing that they're wrong. Now, what happened in the 20th century is the focus of our concern. We had the rise in administrative agencies of a lot of agencies who were authorized to, pass these vast regulatory schemes. And early on, of course, and I'm not the criminal historian scholar that my co-panelist is, you began to get these misdemeanor public welfare offenses. And slowly those were converted into sort of criminal felonies. And in many of these cases, the traditional mens rea requirement is fictionalized. And the offense is not malum in se, inherently wrongful, but malum prohibitum. It's wrong only because the legislature says it is. If you file the wrong report, in many cases, that may not lead to an actual harm, but it's harmful because the legislature says so. And again, we could tolerate a little bit of deviation from the norm, but I think that in the last few decades, it's become rather intolerable and reason for grave concern. So let me now turn, with that primer sort of out of the way, to the case studies. I want to go over two principal case studies. Some are available on our website. These two and a few others available on our website, overcriminalized.com, where we praise some of the work of Professor Sara S. Beale and others like her who've been writing in this area for years. Let me begin with the lobster tale. Our journey begins in the Caribbean, warm waters of the Caribbean, where many of us may want to be in the winter. David McNabb and his 3 business associates were convicted of what the Justice Department characterized as a lobster smuggling ring from Honduras. These commercial fishermen and importers were sentenced to 8 years in prison in 2001 for packing their lobsters in clear plastic bags rather than cardboard boxes. That was one of the principal offenses, which was made into a smuggling and money laundering offense. Now, this is a supposed violation not directly of U.S. law, but of a Honduran regulation. The Marine and Fishery Services of our National Oceanic and Atmospheric Association, or NOAA, seized the multi-million-dollar shipment of McNabb's lobsters based on a tip in a supposedly anonymous fax that undersized lobsters were scheduled to arrive in 2 days in a port in Alabama, and that they would be packed in plastic bags, clear plastic bags, clearly a terrible offense, instead of more opaque cardboard boxes. By the way, if you're a smuggler, wouldn't you prefer the cardboard boxes to the clear plastic bags? But anyway, this made it a smuggling offense. Now, 6 months after the Fishery Service seized the shipment, by the way, it was immediately sent to the federal deep freeze in Florida. I hope you all are glad that we have federal deep freezes in Florida for such contraband lobster tails. Anyway, they examined them, and they've determined at this point what the supposed Nicaraguan offenses are. Well, why do the Nicaraguan offenses matter? Well, the federal Lacey Act, if you've taken upper-level criminal law, you know there is this Lacey Act, makes it a crime to import, quote, fish or wildlife taken in violation of any foreign law. Now, presumably, that's a law passed to prevent poaching of elephant tusks and selling that in the United States. But it's written fairly broadly, and according to one Honduran bureaucrat, there are 2 regulations that Mr. McNabb ran afoul of. One is that lobsters can't be taken unless their tails are 5.5 inches long, and they have to be packed in the cardboard boxes. So the feds go down to the federal deep freeze in Florida. They measure all the lobsters, and they find out that 3% of them were less than 5.5 inches. What I'm reminded of is the Seinfeld episode about shrinkage. If you don't know it, I'm not going to explain it. But I wonder whether any of the lobsters really had tails less than 5.5 inches before they were put in the federal deep freeze. Well, anyway, this converts the whole shipment into multi-million-dollar shipment into contraband because it's commingled. I don't know how all this criminal law operates in practice, but you've heard the horrible stories. Now, here's the real problem. Well, many problems. The sole Honduran bureaucrat who testified was not a legal officer, and her boss and the equivalent of the Attorney General of Honduras filed a report that her interpretation of Honduran law was erroneous because the regulations, every one of them, was either void ab initio or repealed. And you know what the Justice Department's position was in the 11th Circuit after this conviction was obtained? There was an amicus brief filed on behalf of the Honduran government. You're mistaken about our law. The Justice Department told the 11th Circuit they could not credit the Honduran interpretation of their own law because of the possibility of corruption. To me, that's a serious diplomatic insult to another sovereign nation. Now, so these people are rotting in prison, yada, yada, yada. Why do we care? Well, other than they're rotting in prison, which is pretty bad. But let me reflect back on this distinction between the procedural protections and the substantive protections. Did the right to attorney-client privilege help these fishermen who came into port with their lot? No. Does the proof beyond a reasonable doubt matter? No. I mean, the tails either were, they were either in clear plastic bags or they weren't. They were in cardboard boxes. They should have used these pizza boxes. They were either in cardboard boxes or they weren't. Almost all of those procedural protections did these importers, and by the way, people who were buying them from Red Lobster, they were convicted of the conspiracy to smuggle Honduran lobsters in violation of Honduran fishing regulations. So it wasn't just the Mr. McNabb. I will leave this case, though, with a final strange conclusion from NOAA. NOAA declared that the wealth from McNabb's vast harvest was denied to the common citizens of Honduras. Well, McNabb was a citizen of Honduras himself, but apparently not common enough for NOAA. Let me move on to example number 2. And that has at least a slightly happier ending, at least for the defendant. John Cassisi was the founder of Computer Horizons in 1969, built it into one of the leading information technology and service companies in the world. He served as Computer Horizons CEO for 30 years, and yes, he was a great community leader and philanthropist and all that sort of stuff that probably shouldn't matter anyway, but a nice guy. Now, he hears from one of his competitors wants to merge with him. Talks proceed, and talks are then broken off. His competitor says, I'm going to merge with Data Processing Resources Corporation. Well, Cassisi has frequently owned stock in his own company and these other 2 companies. So he goes out and he buys his 2 competitors' stocks. And as an experienced trader, he knows this is perfectly legal if 2 requirements are met. Perfectly legal if, A, he doesn't have a fiduciary duty to either of the companies, and he doesn't. They're competitors. And 2, and by the way, he can even trade lawfully on insider information, which this is, as long as he doesn't have fiduciary duty to either, or the merger is not going to be consummated by a tender offer. Well, he has a reason to believe that, he has no reason to believe it is going to be by tender offer, and the reason he has to believe it's not going to be by tender offer because that's how the discussions with his own company were operating. But you know the rest of the story. Lo and behold, unfortunately for him, the other 2 companies decide to consummate their merger by tender offer. Well, that renders his purchase sort of retroactively criminally, or retroactively illegal anyway. The SEC comes to investigate. And he says, you didn't caught me, I confess. He pays, sells the stock, pays a penalty, pays fine. He thinks that's the end of it. Civil liability here maybe makes some sense. I don't even believe civil liability makes sense here. But after WorldCom and Enron, the Justice Department is looking for criminal scalps. And they go after him figuring this would be a very easy target. Again, let's reflect on what the procedural protections would do for John Cassisi. Nothing. He's confessed. He has nothing to hide. He's a good guy. He just didn't think what he was doing was wrong. Justice Department brings a prosecution maintaining that this is almost a strict liability crime, that the knowing requirement in the security statute is that he knew that he was making the trade. And the good news, though, is that the district judge read into the statute applied the knowing requirement to all the elements of the crime. But for that judge, however, the Justice Department would have prevailed, and the Justice Department has prevailed in its interpretation of many criminal, and Congress is really to blame. Congress either intentionally doesn't have to impose the traditional mens rea requirement to all of the elements of the crime, or it is so sloppy and vague that it allows the Justice Department to interpret them that way. Well, I've about 3 minutes left maybe in my summary. Let me just talk a little bit about the statistics. In 1996, Sara S. Beale and a number of other scholars participated in an ABA task force on the federalization of crime, and they concluded that they counted, among other conclusions they made, that there were 3,000 crimes just in the federal statutes alone. Constitutionally mentions a couple that the federal government might be responsible for. And of course, these weren't just in Title 18, where you could find them, but they were scattered throughout all 50 titles of the U.S. Code. But that's just the tip of the iceberg. Well, let me tell you, there was an update of this study almost 10 years later by Professor John Baker, and he counted approximately 4,000. So we can see, I've seen one attempt to kind of chart the exponential growth of federal crimes. But that's still just the tip of the iceberg, because many of these federal statutes criminalize the violation of any regulation subsequently issued by an agency. This is a sort of blank check to the agency bureaucrats, until revoked or revised by Congress, to write hundreds of pages of regulations. And there is great pressure on Congress and the agencies that if they're really serious about gasoline price gouging, I can tell you that story if you ever ask. There was a bill last year that I wrote a short paper on. They wanted to criminalize gasoline price. The FTC says, don't do it. They were the agency that would have had to enforce it. Don't do it because that's a pejorative term. It's meaningless. We can't define what price gouging is. Well, I'm giving you the short answer on this one. Congress, the bill was killed, but Congress didn't listen to the FTC. Section 1, effectively, of that bill would have required the FTC to define what it was, price gouging, and then impose criminal penalties. Another factor in the federal criminal law is that there's a lot of permitting regimes. You can't build unless you get this or that. You can't modify your factory unless you get this or that kind of permit. And in many federal permitting schemes, the violation of any permitting requirement is a crime. And as you all may know, there are countless little disputes or countless little disagreements. And any one of these disagreements can become the subject of a criminal prosecution. Our kind of quick studies we've sponsored of Washington State and of Texas show that the explosive growth of criminal law seems to be occurring in the states as well. I think it's a particular problem when it exists at the national level, but I think state legislators have the same unfortunate tendencies. Well, with that, I will stick to my time, and we can talk about possible reforms later. Thanks.
I think initially the Federalist Society and Public Law Program might have wanted to have a little bit of a debate, but Todd and I agree on so much that we can't really call this a debate, and I'm happy on behalf of my colleagues here at Duke to welcome you. I want to do something that's a little bit like what Todd did, which is to talk about some examples and then go on to talk about what principles they reflect. And Todd and I are in a long line of teachers and speakers. Jesus used the parables, right? It's kind of a good way to get over some basic ideas. So I think we stand in good stead by using that. And so I want to first tell you about a young woman named Amanda Smisek. And Amanda was a teenager, And she lived in Idaho, and she was a high school junior. She had grades of A's and B's, and she and her boyfriend unhappily discovered that she was pregnant. And she filed for public assistance in advance of the baby's birth. And 6 days before she was scheduled to give birth, the local prosecutor charged them both with fornication. Right? They weren't married, and there was pretty good evidence of the fact that somebody had been doing something. And so Ms. Smisek pled guilty to the offense. She had no good defense, and there was this mother-to-be with a serious conviction on her record, as was the father. The same prosecutor charged 7 other pregnant girls and their boyfriends with criminal fornication as well. What's wrong with this? When you think about over-criminalization, lots of times people think about different kinds of offenses. So they might think about outdated morals offenses, right? They might think about sort of technical or regulatory offenses. So the article that I think you and I were maybe at the same conference where that one was delivered too, and my article is called The Many Faces of Overcriminalization, From Morals Offenses and Mattress Tags, you know, like that thing that says don't tear the, yeah, okay. From morals and mattress tags to over-federalization. All right, so the notion is there are different forms of overcriminalization. Todd, for example, in talking about the plastic bags that those lobsters, I mean, it just sends chills down your back, doesn't it, to think that those lobster tails were in plastic bags, right? So the regulatory or technical kinds of offenses are one form of overcriminalization. Another form that you might have would be morals offenses. Morals offenses that may not fit contemporary values, that may seldom be enforced. In fact, reporters who went out to Utah to try to cover this story talked to lots of prosecutors and public officials, and nobody could remember anybody else who'd been charged in Utah, right, from, you know, in modern times. So a particular prosecutor in Utah got what my mother would have called a bee in his bonnet, right? And decided to do something about what he perceived as a serious problem. Morals offenses have been used in other cases, though, and I want to talk in a few minutes about Captain James Yee. Does anybody in the room happen to remember who Captain Yee was? Okay, well, just remember him. I'm going to come back to him in a minute. Because I want to talk about another form, briefly, about another form of overcriminalization. Well, actually, let me talk about Captain Yee for a minute. Captain Yee was a chaplain in the Army, and he was assigned to Guantanamo. And authorities believed that he was smuggling information out to assist terrorists and others. And the investigation basically began to unravel. They couldn't prove any of their charges, and so instead of proceeding against him for any of the offenses relating to anything that he'd done at Guantanamo in connection with any of the information that he'd learned or any of his interactions with any of the inmates, they charged him with fornication. And that was a particularly stinging charge in his case because he's a chaplain, he's a married man, right? And the charges also gave them leverage over him professionally, personally, and otherwise. Who else has been charged with fornication? Does anybody know the name Kobe Bryant? Remember Kobe Bryant? And there were rape charges, but there were also fornication charges. What happens when you add those in? He says it was consensual, it wasn't rape. Oops. Huh? Must have been fornication. Okay, so we can see some of the dangers that we're going to unpack in a minute with morals offenses. We see a few people singled out for things that lots of other people have done. We see people who might be charged on a pretext when the government is really not concerned with what Mr. Captain Yee did with his girlfriend. That's really not at all what they were concerned with, but they couldn't prove the other things. And in fact, that's a very similar point to the Kobe Bryant, isn't it? They really didn't think that it was fornication. They were charging it as forcible rape, but they had this backup charge, which they could bring out, which I assure you the prosecutors in Colorado were in fact not generally charging. Now, what's my parallel set of cases? And what do I want you to think about in sort of enlarging the focus of your definition of overcriminalization? Todd has already mentioned that the Federal Criminal Code has expanded very broadly, and there are a lot of not only the technical offenses, there's silly ones. I need to inform you that you should not make unauthorized use of the insignia of Smokey the Bear. Or Woodsy Owl, right? We are serious about these things, right? You may not use them. All right, so there's this whole enormous list of federal offenses, but some of them are ones that I think we would all agree should be criminalized. Let's take armed robbery. Now, I'm thinking that we're all going to agree that that should be criminalized. There was a man named Mr. McFarland who committed 4 armed robberies in Texas, and the total netted him, usually there's some imprecision because if you rob a store, they aren't sure exactly how much was in the till. So it was between $1,800 and $2,300, right? Less than $2,300 for the total of the 4 robberies. In Texas, his minimum sentence in state court would have been 5 years. The maximum he could have received was 99 years, and he would have been eligible for parole. So if it turns out that he's a really bad guy, he could be in there for 99 years. If he's not such a bad guy, they might initially give him a lower sentence, or they might give him the 99 years, and then they might decide that when he gets to be middle-aged and he's kind of calmed down and he's gone through some programs, go ahead and release him. But they didn't prosecute him in federal court. He was one of the lucky guys that got prosecuted by federal officials. Do you want to guess what his sentence was? So let me take a guess.
Life, no parole?
Well, first of all, yes, that's right. There is no parole in the federal system. Right? There is no parole in the federal system. He got a sentence of 1,170 months, which is the equivalent of 97.5 years, and you must, at a minimum, serve 85%. That's 84 point some years. Doesn't matter. Doesn't matter if there are extenuating circumstances and the judge would decide in the first instance you should get a lower sentence. It doesn't matter, right? Because these included the consecutive mandatory additive penalties for the gun charges. All right? So federal law is extremely broad, extraordinarily broad. It includes everything from morals offenses to technical regulatory offenses to these silly offenses. Maybe the silly ones overlap. The woodsy, the owl, and so forth. And my argument would be that in the case of the morals offenses and the regulatory offenses and things like Hobbs Act robbery, you have some additional problems that I think might go beyond those that Todd already brought to your attention. Do you remember in first-year criminal law when you studied the death penalty and when the Supreme Court first struck the death penalty down, it was because of what factor? Because it was applied so infrequently to such a handful of cases, and nobody could explain why it picked out the ones, why those were selected and not others. And the court said it was wanton and freakish. It was like getting hit by lightning. What do you think Amanda Smisek felt like? Or James Yee, to be one of the few people that gets charged with an offense like this? So there's a sort of the enormous breadth gives prosecutors too much totally unguided power, right? And the resources in the federal system are such that it's not possible. It is not possible that all of these cases that could potentially fall under these 4,000 offenses, 4,000 and counting, right, constantly, as new regulations and others, it's not possible. Federal jurisdiction is by design an inch deep and 3 miles wide, right? And so there's no way to take more than a few cases. I was describing to Todd when they passed one particular statute, the Justice Department asked every one of the 93 U.S. attorneys to bring 1 charge per year under that statute. 1 per year, right? For a sort of deterrent effect. So the idea was our penalties are harsher than the state penalties, and we would like to sort of send a deterrent message, right? We'd like to send a deterrent message, and so we want to scare people. So we're going to find 1 per year and make an example out of that person. Make an example out of that person? The idea of equality in sentencing and equal treatment is so so inconsistent with that idea. It's kind of like winning a bad lottery, right? You're the one person, you're not going to win the $33 million a year, you're going to win the 33 years, when everybody else is going to get 3 months or 3.3 months or whatever. You're going to get so much more. So there's a structural inequality that's built in because of the difference between federal and state sentences, and because federal sentences in the main are much longer. There's a structural inequality. There's a lack of any real standards that would guide the exercise of this discretion. Thinking back again to first year, I'm just following you on this. Thinking back to first year again, do you remember the loitering cases? Collender versus Lawson, where Mr. Collender just likes to walk in the white neighborhoods and he's got his dreadnoughts, or Papa Christou versus City of Jacksonville, where the racially mixed couples are driving around and they get picked up for loitering, and it turns out like one of them, they were loitering because they were standing on the sidewalk. Why were they standing on the sidewalk? Because the police asked them to, right? And everyone is subject in some way, and the people that get picked just because the prosecutors wanted to pick them for some reason, and the court found that very troubling. We don't have that in each particular offense. You just add them all together. And again, there's a virtually standardless discretion on the part of prosecutors. We have an end run around the various protective state policies and procedures. So, for example, if the state has a procedure that limits wiretaps, or the state doesn't allow the successful prosecution of an individual solely on the basis of the testimony of his accomplice because they think it's unreliable, or because they think that wiretaps shouldn't be authorized in some circumstances because they want to protect your privacy. If you run the same case through the federal system, the federal standards are different and they're more favorable to the prosecution. I'll give you one more example, and then I think it would be the best use of our time to encourage discussion and take questions. In the forfeiture area, the federal and state laws, again, are very different, and the federal law shares all forfeited property back with the agencies that contributed to the investigation and successful prosecution, which means that if state and local officials do all or most of the work, they get all or most of the resources back. Why would state officials want to take a case where they could get a forfeiture across the street, as they would say, across the street to federal officials? Do you know where forfeited drug money goes in North Carolina? School funds, that's right. So if you're a prosecutor and you want all that money for your office, right? And you know if you forfeit it, it'll go to the school fund. Why? Because the legislature wanted it to go there. You do all the work, you take it over, with a little bow on it to the federal officials. You say, would you guys take that and then send me the check, right? And that's exactly what happens. Do an end run around state procedural and in some cases substantive limitations, right? Getting a conviction or getting access to assets that's inconsistent with state policy. But only in those selected cases. So there's both the inequality, and then there's this question of whether state and federal officials should be, you could say, conniving to evade state policies. Now, you can put a different face on this, and you can say, trying to serve the public interest by convicting dangerous people where state law has some defects, and we're not able to do that. And that, I think, that's a well-founded argument if these are matters of true federal interest, number one, and number two, people aren't being treated unequally. Right? So if in an area, something like federal securities law, where most of the prosecutions do run through the federal system, everyone is treated equally, we all know what the standards are, that's fine. In these other areas, I think you have problems of the use of the inequality in lots of different ways, the arbitrariness potentially, the evasion of various procedural standards. And now I think instead of evading the timing limits, we ought to open it up to discussion. That would require you discussing.
Sure, and I'm told we're still being recorded, so watch out.
Well, after hearing about a lot of the problems, is there any hope that this is resonating with, specifically, I guess, Congress at a federal level or at state levels, and that there's any turnaround or people saying we need to stop doing this or reverse it?
well, I'll take the first stab. I would not be working at a poor nonprofit. I'd be making real money if I thought there was no hope. But the hope at this level, if this is a 20-year project, is to slow somewhat the explosive growth. And we take our measures of success rather in that vein. If we stop, there was this bill last year that would have supposedly gotten at the gangs, because, to actually prove that gang members actually commit violent crimes is kind of difficult, and the RICO offense is already, I think, hugely dangerous, but that's not good enough. So this one would have criminalized anyone who associates with anyone else, if any, who share in
I don't think it's us. I think it might be one of you. Is somebody right up next to their little mic?
Oh, okay. Well, we're.
We think they are.
We'll talk. If anyone shares insignia, and
Don't give
they have
anyone
a
your
common,
class ring.
if they have a common purpose, yes, any fraternity, any shared, but any corporation, any business enterprise, any sports team, hopefully they share insignia, would have become a gang, so that if any one member of that enterprise commits a crime, you're all guilty. Well, we killed that one, but it keeps coming back to life. It keeps coming. I could mention 10. We kill most, but they'll come back to life. And some of these would almost federalize. There's one pending right now that would essentially equate street prostitution with human trafficking and slavery, international slave trade. Because that seems to be the good thing to do. So that's my good and bad.
Adam, what I would say is that if you think about the legislative process at the federal level, there's just an awful lot for legislators to gain by passing more federal crimes, and there's not a lot for them to lose, right? So typically, and there are just tons of different special interest groups. One of the relatively recent offenses involves distributing in interstate commerce depictions of cruelty to animals. And they're like movies where people drive stiletto heels into little dogs and things like that, apparently. All right. Well, so the people who care about that care a lot about it, and most other people don't care about it, right? So the adding more federal crimes typically either appeals to a small group, or in the case of something like a gang of youth gangs or something more broadly, is appealing, and people don't see much cost. In fact, my guess is, in terms of the feedback loop and a push back against overcriminalization, that you're always going to get that more quickly at the state and local level, in part because there's a huge financial cost to prosecuting too many people and throwing them into jail for too long, because you have to pay for it, right? And it's a large portion of all states' budgets. And in tough times, when they're trying to balance the budget, what are they going to do? Not build roads, not pay state employees, not expand the state college system to enroll more kids as the population grows. And in the federal budget, the Bureau of Prisons and law enforcement and so forth is a tiny, tiny, tiny drop in a very big bucket of a budget. And anyhow, they run on deficits all the time anyhow, right, as opposed to states, which in many cases have a balanced budget amendment. So I think you're going to see that feedback loop of people saying, well, why are we doing this? This seems like a stupid, why do we really need to throw these people with the plastic bag? You could imagine that happening more quickly at the state and local level when they were looking at places to cut the budget and saying, do we really need to keep these guys in prison? Do we need to have people that measure the tails of the lobsters? When you're looking for somebody to get rid of, probably happens more quickly at the state or local level.
I certainly agree with that the states have some real pressure, but that might, I fear, just make their more arbitrary. It won't stop the laws they'll come up with some other mechanism maybe to limit the cost, but it'll still remain very, and I can't come to Duke. I can't come to Duke without talking about NIFON. what makes that case scary is that these lacrosse players were framed and almost, convicted, but for a serious struggle, because I think most of us from the outside believe that this prosecutor, I think, sincerely convinced himself that these were bad kids. Okay, but it was a real crime with real intent, and some people had ATM records and all this other sort of stuff, and it was still difficult to get out from under the crutches of an abusive prosecutor. A federal prosecutor who decides someone's bad, like a lobster fisherman, can find can get a conviction almost. There's just too many laws for him. If they don't have to confine themselves to real crimes, then it's really scary. So once they decide, by the way, I could tell you afterward, the hints we've gotten from trying to correspond with Justice Department, they decided that McDowell was just a bad person. And he was engaging in, one email we got was unsustainable fishing. Well, unsustainable fishing is not a federal crime or a Honduran crime. So they found some Honduran bureaucrat, and they knew they had the Lacey Act. And they found one bureaucrat to find one or two supposed regulations, the plastic bag versus the cardboard boxes. And that's, the arbitrariness of it is another big part of the problem. Sorry to go on. One question. We have time for maybe one or two more.
So I'm mainly curious about the federal aspect of it, and I'm wondering if you know kind of like a rough proportion of what percentage of these crimes are only possible because of what some people would say is an overly expansive view of the Commerce Clause, and that if it is a significant portion of them, if there's really any way to solve the problem other than by kind of following what the Rehnquist Court started to do and kind of narrowing that definition.
I definitely think it's a huge number, but I'll turn to the true law school scholar for their.
Well, yeah, it's a very large percentage. I don't know, Andrew, I don't know if it's like 80%, but it'd be some number like that. So it's almost all done under the necessary and proper clause, right? And then every crime has to be related to some express jurisdictional grant. So mail fraud is the postal power, right? And if you steal things from the Army, that's the power to raise and sustain, there's some other verb there, armies. So there are some other bases besides Commerce Clause, but it's some huge, huge percentage. I became convinced some years ago that if the Supreme Court could have figured out a way, about the time it wrote Lopez and Morrison, if it could have figured out a way to distinguish between Commerce Clause as a basis for criminal jurisdiction and everything else, it would have narrowed it. I think there would have been a majority to do that. I could be wrong. I mean, it's not like they were all chatting with me individually about what they were thinking. But Lopez comes right at the end of a series of developments that I think just scared the living daylights out of judges who were concerned about the federal courts. And that's another whole aspect of overcriminalization, the pressure on the federal courts, squeezing out other kinds of cases, there was a proposal by Alphonse D'Amato to make every crime that occurred that involved the use of a weapon that had been transmitted in interstate commerce or a part that had been transmitted in interstate commerce a federal offense. And that would have been every gun crime, right? And it would have, I forgot now, it would have increased by like 25 times the number of crimes potentially that could have come into federal court. And it actually passed the Senate, but not the House, and the House told its conferees about a month before Lopez was issued, to agree with that bill, right? The Chief Justice had been going around the country giving speeches against overcriminalization and against that kind of bill, and just getting really exercised about it. And then when the final bill came out from the Conference Clause, from the Conference Committee, it did not include that provision. But I think they felt like, on the court, they felt like they were just that close to the next one passing, right? And that's when they decided Lopez. So I just think that if you think about the institutional concerns, the thing that the court perhaps cares most about is courts.
And then Scalia squished out in Raich
Yeah.
And
Yeah.
he thinks he did the right thing, but it's drugs. So those conservatives, they're not only the true libertarians understand the Commerce Clause. I think you need to run, but I
do.
can
I have,
stay for
I
a
have
minute. If
class
you
and
all
I
need
do
to
have
go,
to leave,
I
but-
understand.
And we've explained to Todd that students will have to leave when they have to for their class.
Sure.
Thank you, Todd.
Thank you. It's great.
I am being more convinced of the whole adage of, hard cases make bad law when it comes to reading the court decisions, but do you think that's definitely true as far as the legislature as well? Because how do you write, as a legislature, the public has this image of people who are really guilty getting off on minute details. So how do you write the law to prohibit and protect against that poaching of the tusks, and yet not get these ridiculous convictions for minor offenses? Like, how do you, as a legislature, in the vague, not knowing sense, write that
That's
type
a great
of law?
question, and it does relate to Adams. When I don't share the panel, I have a whole section on public choice theory, what's wrong, and I'm much more scathing to legislatures than I am to the courts in bad cases, because I have reason to believe that they are truly cowardly, that most of them must know some of these are wrongful crimes. And I'll use the gasoline price gouging as an example. But anyway, I have this whole public choice theory about all the forces being accused of soft on whatever the problem du jour is. Firestone tires, church burning. By the way, there was this myth when I was working as a chief counsel in '95 that church burnings were on the rampage. Well, there was a couple publicized ones. They were actually up no more. I mean, arson, every state punishes arson seriously. Every state there was no Commerce Clause need for Congress, and they knew it. And my boss was one of two who spoke out against federalizing church burnings. But the myth was, but I think that most of them knew that church burning was, but the gasoline price gouging, I think they knew that it was a pejorative term. But who wants to, it's mere cowardice. Now, there's also huge ignorance. One of the reforms, here's one reform I'll throw out. Used to be all criminal laws had to go through the Judiciary Committee, and Judiciary Committees are supposed to be mindful of what crimes are on the book and what danger you can do from broad definitions. But they would have to do work to say, okay, importing fish and wildlife that is an endangered species in that country, or that country certifies as a serious, you could set up a program. Drafting laws isn't easy, but that's what they're paid to do. But I think a lot of what they criminalize, they know is wrong, but they're just not going to put their neck on the line. By the way, why are we talking? I think that as sad as this current track is, we've got to start with the intellectual argument. That's why I'm speaking at law schools. That's why unless I think that ideas do have consequences, and we need to win in the academy. Luckily, for the Federal Society, this is an issue where I think that there is common ground across the ideological spectrum. I have time for one or two more. You all do?
Yeah, I'd just like to hear more about the criminalization of regulatory, like failures to comply with regulation. That seems really troubling to me, just because of the proliferation of regulation generally. And I'm just wondering if you can speak to that a little bit, and especially how common it is for those prosecutions to occur.
Sure. Well, I should start by saying that the estimate of federal crimes itself on in the federal code is 4,000. But the Congressional Research Service said that it could not even count the number of federal crimes in the U.S. Code. It then denied that it couldn't do it, but in a hearing with one of my colleagues, he said, well, I'm going to I understand when Congressman X, and I forget who it was, asked you said it couldn't be done, and I'm going to keep repeating that until you come up with a number. So they can't even come up with that number. We have just wild guesses. But on some some programs, some statutes might spawn, CFRs that are this thick, and they have hundreds of subparts, and not every one of those hundreds of subparts are criminal. It truly is maybe 100 times that many regulations. And if I gave you the whole public choice theory, you would understand that if an agency has both a civil enforcement side and a criminal, they've been given criminal enforcement authority, they have every incentive to make everything that's a civil offense into a criminal offense. And what does that do? Well, if you charge someone with both, it's malpractice not to try to plead to the civil offense. All of a sudden, you've won every civil case you have. To at least try to plead to the civil offense in order to make the criminal go away. And so, again, under the public choice analysis, if you're a special interest group and you're against hurting puppies or whatever it is, the agency is soft on whatever. If it doesn't do so, you can force the agency to make it criminal, but the agency has the special interest to do it on its own. Because isn't its function the most important thing in the world? I mean, they have the tunnel vision, the myopic tunnel vision of someone who lives their whole life in their one little, and each office of every agency has the same sort of myopic vision. So unless there is someone taking the bigger picture, and in the olden days, if it was in Title 18 and the Justice Department had to prosecute it, there were resource issues that Sara S. Beale talked about. Then the Justice Department has to distinguish between the Smokey Bear symbol misappropriators and the slave handlers. But when every little agency has its own authority granted by its own committee in Congress, there's no. Well, with that, I probably should release you. We've got to clean out the pizza boxes. Thanks very much.
Thank you.